that those who couldn't can view it later. So thanks everyone for joining and welcome to this webinar. It remains a sin to kill a mockingbird, perspectives on the Migratory Bird Treaty Act. I want to thank Audubon, Vermont for taking the lead and putting this program together. And I'm going to turn it over to David in a minute. He'll give you a little overview of the program and introduce our speakers today. But I first wanted to offer a little bit of context on how this webinar came to be. Together with Sarah Barker of the Cornell Lab of Ornithology, we co-coordinate this initiative aimed at connecting a network of 50+ regional conservation partnerships, or RCPs, with Audubon groups and other bird conservation organizations throughout the Northeast. And it's called the Northeast Bird Habitat Conservation Initiative, which you can't say very quickly. And really following some conversations that were had with about Cornell Lab of Ornithology's existing work with land trusts, a group of conservationists decided to explore the value of forming a partnership focused on bird conservation and bird habitat conservation. And this Northeast Bird Habitat Initiative was really born from those conversations. And it was presented in late 2018 at the annual RCP Network Gathering, which typically happens in person in November. It'll be virtual this year. But it quickly gained support and a lot of interest from a lot of different RCPs and other conservation professionals. And since then, partners have worked together to establish the initiative and foster some collaborative work among the RCP network and several Audubon groups from Pennsylvania to Maine. Utilizing the expertise and resources and knowledge of Audubon partners and Cornell, this initiative really aims to raise awareness and the collective knowledge about the importance of bird conservation and the role of RCPs and landowners, like the role that they can play in protecting and restoring forest and grassland habitats for declining bird populations in the Northeast. Initiative partners are really just beginning to exchange information about best practices on a variety of topics through a webinar series, as well as beginning to explore pilot projects and work toward more on-the-ground action and projects together. And partner interest in the Migratory Bird Treaty Act and the recent changes around the language weakening this important piece of conservation legislation really inspired this program. And if you'd like to know more about the initiative, please get in touch with Sarah or myself. And our contact information will be on one of the slides that David's going to share. But with that, I'd like to turn it over to David.
I'm not muted. I was about to mute myself. It'll take only another 3 years of this, and then I'll finally figure out how to use Zoom. Well, thanks everyone. Thanks Katie for that kind introduction, and to you and Sarah for kind of having this idea and for inviting us to be part of it. And you know, as I heard the introductions and as I suspected, this is a very sophisticated group. And so I think, you know, and Erik and Robert and I kind of all anticipated this. So we kind of geared our conversation to kind of assume a pretty high level of knowledge. But with that in mind, please feel free to use the chat at any point and interject questions. And I'm happy to pause Erik or Robert or myself and kind of weigh in. And then, and don't be shy about sharing chat questions too that are, position, ideas or different perspectives. We're glad to work that in and have this be conversational. We've got plenty of time set aside. We may not, in fact, use all of it. And we are hoping to also have some dialogue at the end of this to kind of think about what we can all collectively do to kind of advance this public policy agenda on behalf of migratory birds. So with that, let me share my screen. I'm going to kick off this presentation. There, good. Katie, can you give me a thumbs up if you can see that? Awesome. Okay. So we've all introduced ourselves. We'll skip past that. And we've already talked about the initiative. So I'm going to give, just to kind of orient us, just a very quick background. So at the time that the Migratory Bird Treaty Act was under consideration, there was a lot happening that was destructive of birds. There was loss of habitat, which of course we continue to experience. There was significant pollution. There was urbanization happening in key areas. Wetlands were being drained. There's a lot of terrible things happening. But one of the most obvious and public things that really caught the public imagination was the hunting of birds for hats and decorations for clothes and so forth. And also for food. You know, we lost the passenger pigeon was in part, you know, it was being hunted for food. So that was kind of, you know, in the 100 years ago or so, these were issues that were first and foremost and led to some of the most important, you know, environmental laws. And it was in reaction to the fact that there was a growing recognition that some of these amazing different kinds of birds had been lost forever. And that's probably, you know, that's just, there was probably at least a half dozen birds in North America that had already gone extinct by the time the Migratory Bird Treaty Act went into effect. So fast forward to now, how are we doing? And, you know, the news isn't great. The Cornell lab report just was able to capitalize on these incredible new, you know, data management systems, as well as sources of data collected by citizens, to identify that there was this massive decline in birds that we, you know, we had seen in different ad hoc ways, you know, different bird species and populations, but no one had really kind of compiled all this information into one place to look at it as a whole. And when we did that, it looks terrifying looking backwards. And then looking forwards, it doesn't look any better. You know, Audubon did some really careful work to look at, you know, if the climate projections play out the way we're expecting, you know, in terms of, if we end up at a 3 degrees Celsius change by the end of this century, what does that look like? And that puts nearly 2/3 of our bird species at risk. So with that in mind, this is not the time to kind of take our foot off the accelerator as we look at bird protections. So I'm going to turn over in just a minute to Erik, who's going to talk about the kind of what's happening at the national level to the Migratory Bird Treaty Act. And that's kind of the centerpiece of this discussion. But then Robert and I are going to kind of talk about some of the perspective from the state offices and, well, what's happening in states to either backfill or complement what's happening at the national level. But with that in mind, I wanted to just step back for a moment and remind us all that the Migratory Bird Treaty Act is not the only, you know, piece of legislation out there that addresses bird protections. There's the Endangered Species Act, which plays a critical role. There's the Bald and Golden Eagle Protection Act. There's the Lacey Act, really, which precedes the Migratory Bird Treaty Act and deals with trafficking of birds and illegally caught wildlife. And then there's, of course, all the federal laws that relate to habitat protection. There's federal conservation laws, the public lands laws, National Forest Management Act, and so forth. There's the park system. There's the U.S. Forest Service. There's a lot of different ways, and there's coastal zone protection laws, the Clean Water Act and wetlands protections. There's a lot going on that protects birds and bird populations at the national level. And then at the state level, there's equal and complementary kinds of laws that are passed dealing with state lands and state conservation practices. And perhaps, in some ways, most importantly, at the state level are what local land use laws are doing in terms of allowing, suburban sprawl and the loss of various kinds of habitat. So whatever we're talking about when we talk about the Migratory Bird Treaty Act, it fits within that, much bigger, set of laws. And that's, for this group, is probably unnecessary to kind of go through that stage setting. But I mention it because, in part, when I was, when I was dealing with legislators this last couple of years on a bill that we worked on, I found that people were equating the Migratory Bird Treaty Act with, like, if we can pass this law, we'll have solved all the problems for birds. Like why wasn't I happy that they voted for the Migratory Bird Bill, but they were going to vote against forest protections? Why was that a problem from Audubon's perspective? That's just that reminder. So with that, I'm going to then, I think, turn it to Erik to start talking about kind of what's been happening at the national level.
Thanks, David, and Thanks again for the opportunity to join with you all today. Again, I'm a policy manager with National Audubon Society. Have been working on the Migratory Bird Treaty Act issue for some years now, and we'll cover some of the kind of key national issues at play here, including the solicitor's opinion from a few years ago and subsequent litigation, as well as federal rulemaking and some really important legislation. So we'll cover that for about the next 20 minutes or so. So I do want to start, and just to kind of reiterate some sort of basics of the Migratory Bird Treaty Act. Again, this is here on your screen is really the core of the protective nature of the MBTA. This is what's kept birds protected and conserved, and has been the basis for bird conservation for more than 100 years now. And it is very strong language, very broad language that makes it unlawful unless permitted by regulations by any means or in any manner to pursue, hunt, take, capture, kill any migratory bird or any part, nest, or egg. So this has protected birds from both intentional take and kill. So it's helped to regulate hunting, but has also been used for decades to protect birds from other issues, not just hunting, but industrial hazards and other means that birds have been killed. So we go to the next slide. So this term incidental take gets to this idea of, birds incidentally killed through other activities. These are often avoidable, unnecessary deaths that can be prevented through basic precautions, what we call best management practices, as you all may know. So since the 1970s, the federal agency's the Fish and Wildlife Service has utilized the MBTA to help minimize bird deaths from these sources of incidental take, these industrial hazards. Dating back to the 1950s, there had been an understanding that, for example, oil waste pits, these ponds of oily water particularly out west, but other places in the country as well, were killing millions and millions of birds every single year. Again, these can be simply prevented through putting up nets across these pits, or sometimes fencing and other means, or by not actually having these oil waste pits out on the landscape and using other technology. So since the early 1970s, going back to the Nixon administration, the Fish and Wildlife Service has pointed to the MBTA, told companies, look, birds are being killed from your operations. If you don't do something to prevent that, then we will fine you under the MBTA, usually giving companies a chance to take the opportunity to fix the problem before it happens. And so just on oil waste pits, the previous estimates had been that there had been about 1 to 2 million birds killed every year, a couple decades ago. But thanks to the MBTA, it's now been cut in half, though still a significant source of avoidable mortality. Power lines, another issue where millions and millions of birds are killed through both collisions and electrocutions. And going back to the 1970s, in particular, some really important cases in the 90s and 2000s, companies have had the incentive to use these best management practices to prevent these electrocutions and collisions from happening, thanks to the MBTA and thanks to the Fish and Wildlife Service leadership. Oil spills are another one where, especially with these bigger cases like Exxon Valdez, the BP spill in the Gulf, where 1 million birds were killed, the MBTA had been a core part of the criminal liability. And in the BP spill, there was a $100 million fine that went right into the NACA program, North American Wetlands Conservation Act, which helped these birds recover. And that's thanks to the application of MBTA to incidental take. The fact that these birds were killed, by any means or in any manner, has been the critical incentive and ability to recover. So both Republican and Democratic administrations for decades have interpreted the MBTA to apply to incidental take. There had been some pushback by companies who had faced some of these fines and some challenges in court. And so it had become a small controversy in the environmental sort of policy world, not as big as maybe the Endangered Species Act and some other issues, but there was an effort under the Obama administration to address this this issue and address the MBTA incidental take issue by proposing a permitting approach that would allow companies to apply for a permit so they would have more legal certainty, because there's never been a permit available for companies for incidental take, unlike the Endangered Species Act, so under the MBTA. And so that was not finalized, but before the administration left, they did put out a legal opinion of their own in 2017, restating what the interpretation of the MBTA had been for decades, that it does apply and does prohibit incidental take. So if you go to the next slide. When the Trump administration came in, they took on this issue very quickly. So in just 2 weeks after the inauguration, February 6th, the new administration withdrew the Obama administration legal opinion. So they suspended that opinion. A couple months later, they also withdrew that rulemaking process that would have developed a permit for the first time for the MBTA. There also have been some congressional attacks on the MBTA, which was a big concern, especially in 2017. There was an amendment that passed in November, and there was a very serious threat that the MBTA could have been amended itself in a very harmful way. The next month, a few days before Christmas, right as we're about to, as most were celebrating the holidays, then the Trump administration issued their own solicitor's opinion. So this is issued by Daniel Giorgiani, who was then the acting solicitor for the Department of Interior, issued this opinion that interpreted the MBTA to say, for the first time from any administration, that the MBTA does not prohibit incidental take. So the key language there was that the statute's prohibitions on pursuing, hunting, taking, capturing, killing only apply to affirmative actions that have as their purpose the taking or killing of migratory birds, their nests, or their eggs. So it has to be purposeful. That means that you can no longer fine a company when a bird is killed by an oil spill. You can no longer fine them when they're electrocuted, on a power line, for example, and so on. So the argument that this Interior Department made, we of course thought was legally flawed in many ways, but of course also deeply harmful to bird conservation and bird protection. It'd be hard pressed to point to a more significant rollback in bird protections in our history. So again, the legal arguments, I won't get into too much of the details, but relied on some we think pretty absurd arguments about going back to what what take means, going back to common law definitions, what the purpose of the MBTA was originally to address hunting in their view, and that it would lead to these kind of absurd results that would criminalize everyday behavior, which these are some of the arguments that you continue to hear. So they followed up that opinion with some guidance memos, which were issued by the Fish and Wildlife Service, kind of interpreting this solicitor's opinion. And they also put out a new memo about nest destruction, so allowing entities to remove even active nests because of the solicitor's opinion. So we know that this has been deeply harmful. Groups have worked on finding Freedom of Information Act requests to see what has been going on behind the scenes. And we've seen a number of examples of harm to birds that was important in our litigation going forward, and also just to show what this actually has meant on the ground for birds. So there have been a number of oil spills, for example, including in the Northeast. There was a spill off Cape Cod in January 2018 near Woods Hole, a fuel oil spill where there were a couple dozen dead birds found near that site, including birds that were covered in oil. But email showed the Fish and Wildlife Service and Interior, because it involved, quote, incidental take of birds, there's, quote, currently no enforcement action plan by the Office of Law Enforcement. So we saw that example. We saw some pipeline spills out west. A number of smaller spills have happened in Alaska, Louisiana, Florida. And again, there's been no enforcement since the solicitor's opinion. Some other examples, power line electrocution. There was investigations that were shut off after the solicitor's opinion came out. A snowy owl in Delaware was electrocuted, and they shut that down, due to the solicitor's opinion. Ospreys as well, and a number of osprey nests had been removed, including some examples in South Carolina and California, where there was no ability to provide any accountability or prevent that from happening. So it is having serious impacts now, and unfortunately will continue unless we have durable protections for MBTA going forward. The next slide, I just wanted to note, in the guidance memo, there was an example which I think really highlights the absurdity of this new policy. So they provided this example of, say, someone, a homeowner was going to remove a dilapidated barn with nesting owls inside. And even if the homeowner knew that if they destroyed the barn, that the owl nestlings would be killed, they said that would not be a violation of MBTA. So even if you knowingly harm birds, including these cute little barn owls, that is not a violation because that's not the purpose of that activity. So it creates a lot of absurdities, a lot of new uncertainties, and a lot of gray area about what this even means, and the ability, make it even harder to address even intentional harm in some points, because the burden is on the Fish and Wildlife Service to prove what the state of mind was by a person or an entity. So we go to the next slide. So naturally, Audubon and our partners quickly got into gear, filed litigation in 2018. There was a few different cases. One was the National Audubon Society versus Department of the Interior. There was a separate NGO case with some other conservation partners. And then 8 states also filed a lawsuit to challenge the solicitor's opinion. And that included a few states in Northeast New York, Massachusetts, New Jersey, where the state attorneys general filed a lawsuit on behalf of their states as well. So we made similar arguments, essentially coming down to the fact that this solicitor's opinion violates the law. It violates the Migratory Bird Treaty Act. It's arbitrary and capricious. We made a few other claims relating to the Administrative Procedures Act and NEPA, National Environmental Policy Act. But essentially it comes down to the fact that this contravenes the MBTA. Looking again at that text from the first slide where I started, if you look at the treaties themselves, which talk about things like protecting birds from pollution and environmental harm. If you look at the purpose of the MBTA and the treaties themselves, congressional history, agency practice, it's quite definitive and unambiguous that the MBTA does in fact protect birds from incidental take. So we were able to move through one of the hurdles last summer, and the district court, the Southern District of New York, which is hearing the case, rejected a motion to dismiss the case, argued that we did have standing to sue. And then just last month, we had a huge victory when Judge Valerie Caproni, the Southern District of New York, ruled in our favor in what's called summary judgment. So didn't even have to go to oral argument, and ruled that the solicitor's opinion was unlawful. It overturned the opinion It vacated it, to use the legal term, meaning it does not currently have any force of law. So this was a huge win. We feel quite vindicated, and it was a very strong ruling. The judge found that the opinion is contrary, quote, contrary to the plain meaning of the MBTA, quote, runs counter to the purpose of the MBTA, and found that really the opinion was quote, a solution in search of a problem. So point by point, it really just took down the entire argument for the opinion. So we were quite pleased with that. It did not remove some of the follow-up guidance. So those are still active. So we're working to find out, more about what that means. And so I'd see the question in the chat here. The solicited opinion was overturned this year. So just recently, August 2020. However, we still have a ways to go to make sure that birds will be protected going forward. For one, the agencies do have a lot of discretion when it comes to enforcing the law, unfortunately. So, we're not expecting them to immediately go out and start enforcing the law. In fact, we do expect the Interior Department to appeal. We haven't heard for sure. There's still a couple weeks for them to actually file the appeal. And they are moving forward, we expect, and something we've heard in the press so far, that they're moving forward with rulemaking as well. So I want to note on the next slide, just in reference to the title of this presentation, the powerful opening from the court decision. Encourage folks to look at it if you haven't and you really want to dive in, but this is how it began. It is not only a sin to kill a mockingbird, it is also a crime. That has been the letter of the law for the past century, but if the Department of the Interior has its way, many mockingbirds and other migratory birds that delight people and support ecosystems throughout the country will be killed without legal consequence. So, really powerful, moving writing, I think, from the judge as well. And, it got a strong ruling, but we still got some ways to go. So I do want to address the rulemaking that has been going on the next slide. The Interior Department has, taken this kind of two-pronged approach to go after the MBTA, the solicitor's opinion and also rulemaking. Rulemaking is more difficult for us because it can be more difficult to overturn. A legal opinion can just be tossed out without any public process. And again, even though we had challenges to make our case in the courts, a rulemaking, could provide the agencies with some more deference, and it will take longer, to overturn potentially. So it is a huge threat still to the MBTA. So back in February 2020, the Interior Department issued a proposed rule, essentially just codifying the solicitor's opinion. So pretty much just putting the language of that opinion in the key language about, requiring purposeful actions to be prohibited under the law into the regulations that implement the MBTA. So this happened, kind of right as the COVID crisis was really becoming a major crisis. They moved forward without extending the comment period, shut it down in mid-March. Despite that, there was a lot of opposition. We had about 200,000 letters were sent in opposing it. A number of state wildlife agencies, former Interior officials, and many more still wrote in opposing this proposed rule. Despite that opposition, the Interior Department moved forward with their NEPA process and issued a draft environmental impact statement in June 2020. Again, still, as folks and families are dealing with the health crisis, economic crisis, they decided to move forward with this. And what they put out was deeply and fundamentally flawed in many ways. Their analysis really did not even address the change in policy from, protections to no protections. Just this kind of small change in actually codifying the opinion in terms of what the environmental impacts are. It really did not have any scientific analysis of what this means to birds. It was about 250 words in the key paragraph about what the impacts are to birds. Did not have the necessary range of alternatives, so it didn't even consider an incidental take permit. And despite that, the document did recognize that there would be an increase in bird mortality. There would likely be an increase in Endangered Species Act listings, more costs to states that might want to address migratory bird protections, reduced revenues for businesses that depend on birds, reduced ecosystem services. So it really was shocking to see, despite recognizing the serious harm that this rulemaking will cause, that the Fish and Wildlife Service, which has a mission to protect and conserve birds, really was born out of bird conservation, decided to move forward with something that will be so obviously harmful to birds. We did see some press recently that the administration intends to move forward with this rulemaking. They have said that they expect to have something out in the fall or winter of this year. We, of course, hope that they do not put out a final rule, but have said previously that they intend to do so, and perhaps in the fall or winter. So, I just want to emphasize that this is the next stage of the fight to protect birds. This would be an even more significant threat than the solicitor's opinion even was. So we have our work cut out for us, and we've got a lot to do to fight back against this rulemaking. If you go to the next slide, and I just got a couple more slides here, but I want to note that there has been a widespread opposition to this from across the country. As you know, there's been hundreds of thousands of letters. More than 500 organizations for every state a couple years ago signed a letter. As part of the rulemaking process, more than half the states in the country have weighed in, either through the attorneys general or through state wildlife agencies. So about 20 state wildlife agencies have submitted comments opposing this. Flyway councils, the Atlantic Flyway Council, for example, has been very outspoken against this rule, along with the Mississippi and Central Flyway Councils, which are pretty important partners with the federal government in managing migratory birds. House and Senate members have been quite outspoken. The chairman of the House Natural Resources Committee, the ranking member of the Senate Environment Committee, dozens of other members of Congress, interior officials going back from every Republican and Democratic administration since the Nixon administration have been quite outspoken, along with hundreds of other staffers. And actually, the government of Canada submitted public comments with strong objections to the rulemaking, and they filed those as part of the draft EIS comments. So again, this implements our bilateral treaty with Canada as well as 3 other nations, and so that's very significant. And then organizations and individuals, scientists, tribes, sportsmen, birders across the country have been quite outspoken. So there's a lot of opposition. So if you go to the next slide, and we'll finish up here just talking about the legislation. So the Migratory Bird Protection Act has been one way we've been going about trying to secure protections under the MBTA. So this was introduced earlier this year in the House by Congressman Lowenthal from California. So what this legislation would do is it would reaffirm protections for birds from incidental take. So it would amend the MBTA to clarify that birds are protected from this source of take. And it would do a number of other things as well. It would raise resources for conservation by establishing a couple of new fees. And that's part of a permitting framework, which aligns with what the Obama administration was attempting to do about 5 years ago. It would direct the Fish and Wildlife Service to create an incidental take permit, particularly through a general permit based on classes of activity. So for example, if you're an oil company has an oil waste pit and you're doing all the best management practices that can be expected, and you pay these fees, which would then be directed back to conservation, then you can receive a permit and you would have more legal certainty. So we see this, this would be available for renewable companies as well, for wind companies and solar companies who would like more legal certainty under the MBTA. This would be an opportunity for them to get that certainty and also increase the adoption of these best management practices. So we see this as a good path forward, potentially a win-win for conservation and regulatory certainty. And we have been having some success moving it forward. The House Natural Resources Committee did take it up earlier this year and passed it out of committee. It has now got about 95 co-sponsors, including bipartisan co-sponsors, and a number of Republicans, including some folks in the Northeast have sponsored it. And so that makes it available for a potential vote on the House floor. It's unclear at this point whether there will be time in the House calendar this session for a vote in the House floor, but we are calling on Congress to take up this legislation, particularly as the Interior Department is still moving forward with the rulemaking. So we also are working on the Senate side with a number of champions in the Senate, and we hope potentially next session to have a companion bill in the Senate as well. So with that, I think I will end there and turn it back over.
Thanks, Erik. That was really terrific. It was very helpful. I should, as we shift to talking to Robert and I talking a little bit more about what's happening in the States, I want to note that, Erik's work on this has not just involved work at the national level. He's been very supportive of states that are engaging in this work. And I couldn't have done the work that we did in Vermont without his support. It's, I think, one of the unique strengths of the National Audubon Society that we have both this kind of national policy structure and expertise, as well as the on-the-ground work that we're able to do in the States. So with that, let's turn it to Robert and to talk about what's going on in Connecticut.
Great, thanks a lot. And Erik, that was a tremendous presentation. And I just want to echo what David's saying. You've been amazing. I mean, we would not be where we are with a lot of what's happening in the federal government without your hard work and your thought leadership. So I just want to thank you, and I want to thank National for the great work that they're doing on this particular topic. This was a topic I really wasn't all that familiar with, and whenever I had a question, I could give Erik a call or shoot him an email, and he was really great. So listen, what I'm looking at here is, what if it all goes south, right? What happens if the Migratory Bird Treaty Act becomes something that no longer exists? What happens then from a state perspective? Are we able to, at the state level, provide some kind of a backstop? What's the law at the local level? How does that parallel with the federal law? Because quite frankly, in the current context of things, the regulatory agencies, and just sort of full disclosure, I was a 26-year veteran of the Connecticut DEEP and spent a fair amount of that time doing some enforcement, particularly in the air quality area, but also in the environmental conservation area. And what you have is a situation where we relied significantly on this federal law in order to make certain that people would comply. So let's take a look at what we have in the event that the Migratory Bird Treaty Act doesn't exist. What do we have in the way of current law on the books in a state like Connecticut? So next slide, please. So this is the current statute in Connecticut. You can see it's sort of, kind of, not really as perhaps as strongly as the Migratory Bird Treaty Act. Talks about the fact that no person shall hunt, take, and take is an important word here, or attempt to take, or assist in the hunting, or all those other things, to take any wild bird. So it's not just a migratory bird, it's any wild bird. And remember, an exception from this would be all the hunting statutes that allow people to take birds. The other element of this that's, I think, significant, and we'll talk about this a little bit more, is if you violate this provision, then you're guilty of a Class D misdemeanor. And we'll talk a little bit about what that means. Next slide, please. So taking, and this is really important, under Connecticut's definition, taking means shooting, pursuing, hunting, fishing, and this is the operative word, killing. So at this point in time, the agency has not had to go after incidental permit litigation because they had the federal government to rely on. If there was an issue with someone, an incidental take, and the state of Connecticut wanted to do something with it, they'd pick up the phone, call the Department of Interior, and ask them to potentially move forward on that. If there was nothing that could happen at the federal level, then the state of Connecticut would have to rely on these statutes to try and bring an action. And next slide, please. So at the state level, I think folks have to recognize that the way the Environmental Conservation Branch or our Wildlife Division works, a lot of how they get compliance with laws and regulations is through education. So what they do is they educate people, and they have a whole bunch of different ways that they can do it. And they also do something called the Wildlife Action Plan. And the Wildlife Action Plan is a plan that the states put forward to deal with species of greatest conservation need. And I think all folks are going to understand what that is. I'm going to talk a little bit about that in my next slide. But the point is that that education piece, the notion of trying to protect birds because they're an important species or they're important to people who enjoy them, is that we would have to take a look at current law and make certain that it was strong enough to be able to enforce in the event that we started having more significant incidental take in the state. So the question then becomes, is the Wildlife Division really in a position to do that? Historically, the Wildlife Division has done a lot in the way of education, but not so much in the way of permitting. So the idea that the Migratory Bird Protection Act that Erik talks about would provide resources to actually create these general permits would be a new sort of lift for the state government and the state entity. So funding that type of work would be significantly important. Next slide, please. So beyond the Migratory Bird Treaty Act, and again, I put all this together because it's a lot of how the Wildlife Division does education. One of the things we've been working on at the national level is something called the Recovering America's Wildlife Act. And if passed, and this did in fact pass the House, so it's kind of gotten partially through, but not through the Senate. But the idea here was that the federal government would start to fund in a more significant way these wildlife action plans and state governments. For a state like Connecticut, it would be somewhere between $11 and $12 million annually. And I believe the bill that passed Congress, that would be for a 5-year term. It was authorized, but it would still have to have money actually allocated from the budget. So important for us to realize that not only if we lost the federal level, we'd also still need to try and get the resources to do what we need to do at the state level, because quite frankly, at the state level, state wildlife agencies, for the most part, have been decimated by retirements and lack of adequate funding. Next slide, please. So what else happens at the state level? The other way, and this is probably the most classic way that enforcement happens at the state level, is that we use a police force, the Connecticut Environmental Conservation Police Force. And they're the ones who would probably bring an action under the statutes that we're talking about. They would basically issue someone a citation for illegally killing a bird. And then that citation would end up going to a prosecutor who would have to prosecute that in a local criminal court. That's significantly different than what happens at the federal level, where the federal attorney general can bring a large action against a big company seeking fines. So at some level, the work that our con enforcement officers do is significant, but in order to move from where we are now, which is basically guys who do hunting and fishing violations, to move that into a general permit type of category will be complicated and will require resources. Next slide, please. So this is what I was talking about before. What does it mean to have to be guilty of a misdemeanor, a Class D misdemeanor? Well, you could go to jail for 30 days. I don't know that that's ever happened in this state, and quite frankly, I don't know whether that's ever happened under the Migratory Bird Treaty Act, whether anyone's actually been in prison for that, but it is theoretically possible. And the second thing, and take a look at the penalty, not to exceed $250. And again, if we went to the earlier definition, each individual death is considered a separate offense. So you could add those dollars up significantly should we get to the point where we would actually bring this kind of an action. Next slide, please. So what does this mean for places like Connecticut? I mean, we relied historically on the federal government, because the federal government was effectively, we refer to them as the sort of the gorilla in the closet. They would be the folks who would basically make things a federal case if people don't pay attention. And that gets the attention particularly of industry. The last thing they want to do is have the federal government come in and tell them what they're doing is inappropriate. So I just point out here one of the cases that I'm familiar with, and this, I think we talked a little bit earlier about these birds here in terms of the habitat that they're dealing with, ospreys, the nest that you can see where they're actually trying to build a nest on a power line, and an alternative that might work where you actually take the nest and put it above the power line. Now, this is something that had been sort of being worked out between the Federal Fish and Wildlife Service and industry, where they were moving towards this type of mechanism to have it as a best practice. But without the Migratory Bird Treaty Act, this type of innovation, this type of alternative may not take place. So the loss of the Migratory Bird Treaty Act is significant, and it's something that we're going to have to fill in at the state level if we're not successful following the work that Erik's done. The other thing I need to point out, and I think this was something that David talked about earlier, the idea that there are other laws. We still have things like the Lacey Act. The Lacey Act is still something our law enforcement police officers do on a regular basis. But we also have, for example, in areas like wind energy and building in glass and communication towers, there are areas in the law in Connecticut where these things are actually being looked at in a more significant way, in a closer way, where they're not necessarily relying on this environmental conservation statute that I'm talking about. But for example, in wind energy, Connecticut established something called a Commission on Environmental Standards, and Corey Folsom O'Keefe from our office actually sits on that. And part of their role is to help establish proper standards for wind siting. But you can see all these other listing of all these other activities that need to be taken a look at. The general permitting would require sort of an in-depth analysis of each one of these to come up with best practices, which is why the Migratory Bird Protection Act at the federal level is so significant. It's important that we pass a law at the federal level to clarify this so that all the states are sort of on a level playing field, and hopefully we'd have enough resources to sort of move through that. Next slide, please. And I think I'm going to send that back to David. That's what I had to talk about today. I don't think I've missed anything in terms of things that I wanted to say. So I appreciate the opportunity. And David, your turn.
Thanks, Robert. That was a great setup and a great point about kind of the need for a mix of different kinds of laws with different kinds of authorities to tackle all the issues facing birds and threats to birds. And it's true in Vermont, as it's been true for most states, that we never had much of a state role in terms of using state authority to enforce against migratory bird impacts. We relied heavily on the U.S. Fish and Wildlife Service. We're not aware of any actual enforcement actions or formal actions that were taken in Vermont, but we definitely knew there's been good collaboration, as there is in an ongoing way, between the State Department of Fish and Wildlife and the U.S. Fish and Wildlife Service. And there's a lot, and I've experienced this at Audubon, I'm sure a number of you have as well, that when people would call up and say, can I do X? That would cause the destruction of bird nests, for instance. We could say with a straight face, no, you can't do that. That's a violation of the law. And because for most of the country and most of our communities, that matters still. They don't actually need the threat of enforcement to decide to avoid harming birds. Just knowing that was enough. We had a situation where there was a school district that wanted to take down a large chimney, and we told them, well, it should be against the law. It used to be against the law, and that was good enough for them. They're like, we'll wait until we know that the chimney swifts aren't nesting there. So having a federal law is important, and it's just one piece of a bigger puzzle. In terms of part of the reason that Audubon decided to take on and advocate for a state-based version of incidental take provisions was a desire to kind of have a backstop for our own state, for actions within our own state in the event that there were a major oil spill or some industrial activity that was having kind of significant population level impacts on birds. And just so that, that our state had the authority, if it chose to exercise it, to deal with something that was a really egregious and harmful activity, independent of whether there was any intention to harm the birds or any issue of whether there was intention. So part of it was substantive and state-based, but the other part was to be part of a national strategy, to be part of an effort across the states, and hope that Vermont might be able to lead the way for states that didn't already have this authority to pass these laws, to put pressure on the industry nationally, to realize that in the absence of a national law implemented in a consistent way by the U.S. Fish and Wildlife Service, they were going to be left on their own, state by state by state, to have to deal with different kinds of state laws. So that was our theory around it. We were really lucky. I had some early discussions with a couple of key legislators in our state government, Representative Kerry Dolan and the chair of our House Natural Resources Committee, Amy Sheldon. And they ended up being the lead co-sponsors, and also then talked with some of the leaders on the Senate Natural Resources Committee. And everybody had the same reaction, regardless of party. This was not an ideological issue. Everybody agreed that the old law had been working just fine, and that rolling it back just didn't make any sense for Vermont. And so Kerry Dolan and Amy Sheldon introduced this bill. I wasn't sure at the beginning of the biennium if it had any chance. This was a session in Vermont in which the legislature decided to take on a major rewrite of our major state land use law, Act 250, which is a total chaotic political mess that was going to consume a huge amount of legislative time. There was several global warming bills that were on their way and highly politicized and big ideological disputes. And a pretty strong commitment from the House and Senate leadership, they were going to move these other bills. I thought the chances of our little migratory bird bill sneaking through all of that were slim to none. But nonetheless, it came up and it got a hearing. And I'll talk a little bit about the process, but let me just jump to the end and tell you what's happened now, so I don't hold you in suspense. But the result was that we, as of last month now, mid-September, the House and Senate had both passed the same version of the law, the language that you see here, and that language is on its way to the governor, and I assume the governor is going to sign it. All of the indications are that he will. So we'll have this language will become part of the state laws and statutes. And the key operative language is at the very bottom of this set of language that you're looking at, which says that where the take occurs and the intent was not to harm or kill the bird, but the bird harm or death was a direct and foreseeable result of the activity. That's incidental take in a nutshell. And so let me talk a little bit about some of the drama to get there. One of the issues that came up right away was, well, wait a minute, that's pretty broad language. Are we talking about, what if my car hits a bird or my cat, I let my cat out? And, I did indicate, and shared particularly related to the cats issue. I thought, people should keep their cats indoors. But I said, there's no history of the Migratory Bird Treaty Act being used to, prosecute cat owners. Though I wouldn't mind if they did, but there's no history and no expectation that has happened or will ever occur. And I couldn't expect that or imagine it for the Department of Fish and Wildlife. But nonetheless, we ended up putting in some language in the bill that gave the department express authority to focus on those kinds of incidental takes where there was at least a local population impact. So we're kind of had to deal with this issue. Another issue that came up was wind turbines, and our local utility, the lead utility in the state of Vermont is Green Mountain Power. They put in a very controversial set of wind towers on a mountaintop ridge in Vermont, and went to great pains through the permitting process to convince everybody that there would be no impact on birds And then they went to great pains to study all the impacts and found that there was limited impact. I'm not sure if the jury's out on that one, or if there's still some debate that needs to happen. But nonetheless, I say that because the utility had been very adamant and outspoken about the fact that their wind turbines did not impact birds. And so when I approached them and said, will you support this bill? They were really uncertain and worried and kind of parsing the language and say, well, wait a minute, we could be liable for all sorts of stuff. And I said, well, time out. If it's true that you're not actually impacting birds, as you say, then this law should be of no concern to you. And after a lot of back and forth, they ultimately conceded that perspective and ended up somewhat tacitly supporting the law. That is, they didn't oppose it and showed up from time to time and said they weren't too worried about it, which was a big issue for the Vermont legislature. The other entity that was a key player was our Department of Fish and Wildlife. The Commissioner of Fish and Wildlife, a guy named Lewis Porter, was very active in supporting this bill. He was interested and concerned to make sure that it didn't impose a significant additional strain on his department, because as Robert noted, state fish and wildlife departments are all experiencing a loss of revenue as hunting fishing licenses decline and as general revenue just drops. And they've been particularly hard hit and have a lot of unfilled positions. So he was worried about resources, but beyond that, he was very supportive. He and his staff, our bird lead in Vermont for Fish and Wildlife is a guy named Doug Moore, and they were great. They were really supportive and helpful, and that made a huge difference in terms of getting this across the line. So I think I'll pause there and turn it back to Erik to talk about some of the things that may be happening in other states. But I'll just conclude by saying this law passed with almost unanimously. There was one voice of one House member on the House floor in one of the votes that said no. But that's, as far as I can tell, it was the only person that opposed this. So I tried to describe that to one of Erik's colleagues down in the Washington, D.C. office of National Audubon Society, and she didn't actually believe me. She couldn't conceive of something where like 99.9% of the legislature agreed on something. But this was one of those things. And I think it's an important, interesting lesson for us to think about as we go forward on this kind of work, that if we can find ways to frame these issues about something as charismatic as bird protections and a set of protections that have been in place as long as the migratory bird protections under the federal level have been in place, we can get large bipartisan coalitions to support this work. Anyway, so Erik, I'm going to turn to you to talk about what might be happening in other states.
Sure, and I first just want to thank and applaud David for his amazing leadership in moving this legislation forward right at the finish line there. It's really incredible work navigating this legislation and pushing it forward, especially under these extremely challenging circumstances. I think it would have been difficult, navigating all these dynamics so successfully anytime, but with a lot of skill and great work. It's really amazing to see that. So I also just want to provide a little bit other sort of context and background for some other states. I will note that the Association of Fish and Wildlife Agencies has been engaged on this issue and put together a working group and report last year about incidental take and how states and state wildlife agencies can address this issue. So they did a number of good things, including put out a survey to agencies to understand what types of, what sources of take are important and relevant in their states. What are some of the issues at play that may be barriers? And they did note that a lack of regulatory authority was a barrier for many states in addressing these issues. Collected a number of best management practices that folks can look at, and did an analysis of the state laws across the country. And so that analysis found that there were according to their review, about 17 states that had some form of incidental take provisions or could be relied on for incidental take protections in their state laws. A number of states were indeterminate, meaning that there may have been connections in their state laws to the MBTA itself. And that was an issue in California, which I'll talk about in a minute. But about half the states did not have sort of clear provisions. And so in those cases, legislation can be particularly important if states are interested in addressing that. Otherwise, if they do have some provisions, they could go right to, a regulatory approach, or they could, enforce the law in some cases. And so there's a number of options available. There is also model language in that report that states can look at from both the regulatory and legislative side. So California was an early leader in this effort. Going back a couple of years ago, they worked out some legislation. First, they had put out a legal advisory from their Attorney General and Department of Fish and Wildlife, interpreting their own laws to say that the law does prohibit incidental take. Then they moved forward with legislation as well, because they had this issue where their state laws were connected to the federal MBTA. So it could have made it as a sort of a loophole that would have made it difficult for them to actually enforce the law. So what they did was pass legislation, the California Migratory Bird Protection Act, AB 454, and that gave clear authority for the state to be able to protect birds from these various industrial hazards. So that passed the legislature and was signed by the governor last year. So that was a big win for the state. And so now we've got basically 2 states that have passed legislation. Again, just waiting the signature in Vermont, but making some important progress there. Also just wanted to note that Virginia, the state of Virginia, is also looking at this issue. Or earlier this year, they put out discussion draft regulations that would create a permitting program in the state for the first time. They were had an issue with this important seabird nesting colony in Virginia, in the Hampton Roads area, and there's a lot of frustration about having a lack of authority and incentive to protect birds in the state. So they have actually moved forward with this permitting approach, similar to what is in the Federal Migratory Bird Protection Act legislation and what the Obama administration was attempting to do. So for folks interested, that is out there. You can read about that more on the agency's website as well. And so that is expected to move forward. We're awaiting sort of the official proposed rules that could come perhaps this fall. And so that would be another important step forward, and another state that's kind of helped leading the way on this issue.
Thanks, Erik. That was great. And just in closing, I kind of want to open the conversation. Anybody who wants to weigh in, either on chat or feel free to just unmute yourself and pipe up. But I think one of the key messages for states, based on what Robert and Erik and I have shared, is there's options. There's Attorney General's opinions to interpret existing authority. There's using existing law and regulations more effectively. There's education outreach. In some cases, the stars may align like they did in Vermont to get legislative authority and clarity around it. I do think, with my lawyer hat on and a former, environmental agency administrator, the ideal setup really would be what Erik's describing that Virginia's considering, and which the Obama administration was looking into, which would be to have enough resources and structure to support a permitting program, so that the regulated community kind of knew what the rules were and could get approval, and the appropriate conditions could be put on things in advance. I think one legitimate frustration of the regulated community is the Migratory Bird Treaty Act is pretty broad, and the authority is pretty substantial, and it does, in theory, reach pretty small levels of impact. And so, and if there's one thing the regulated community and, companies and business people don't like, it's uncertainty. They're willing often to accept some level of restriction as long as they get certainty. So I think that's where ultimately I would love to see Vermont get to, but that's going to take a heavier lift because it means talking about resources. But I welcome thoughts or comments from folks in the audience.
I have one. So I'm from Mount Grace Land Conservation Trust. We're in Massachusetts. I know the state started a program. It's the Forestry for the Birds. They have an incentive programs for all the landowners. So if you're in Chapter 61, you're planning to do any forestry, they start an incentive program that if they want to upgrade their forest stewardship plan, that they have the funds for the landowners to pay or get reimbursed for when the forester does their plan, as long as their plan incorporates a bird habitat improvement plan in it. So I know that's what the state did for Massachusetts. I don't know if you have the similar one in Vermont.
Yeah, and Nancy Patch can probably speak to some of that. She's one of our expert state foresters. Nancy, you want to describe what we have in Vermont?
Yeah, sure. So Foresters for the Birds program has been training foresters for a number of years to include habitat assessments within their plans. And our NRCS program, which you've just referred to, is also on board with identifying particular silvicultural practices that are for bird enhancement. And so there's funding specifically for bird habitat improvement. We don't have that really cool thing that you just mentioned about funding specifically related to management plans that identify bird habitat. Our CAP plans are just a broader CAP plan, but we definitely do. And then there's another program, and I think, David, you can help me with this one, but Woodland and Warblers, that is also in training additional foresters throughout the state to incorporate bird habitat management within their forest management plans. Those silvicultural guides that we produced to help with forest bird management have been adopted by the Department of Forest and Parks as approved guidelines, approved silviculture guidelines. So we've done a lot of work. We've additionally helped a lot of neighboring states and states up and down the flyway enhance their programs.
Yeah, thank you for that, Nancy. Thanks for that great question, Kim. It made me think about, one of the things that came up in the legislation and often comes up in these policy discussions involves, at least in rural states, what about forestry and agriculture? We know, for instance, what if we had a farmer on one of the committees say, look, when I mow my field, sometimes I'm able to wait until the bobolinks have, fledged. Sometimes I can't. I just need to get out there and mow. Am I going to be liable under this law for that? And that was, that led also to a similar discussion that we had about cats. If it's not causing population level impacts, even local population level impacts, it's not really likely to be subject to enforcement. But it leads to a great program, that I described that Mass Audubon has been a leader on, which is the bobolink program. And whether it's this, these kinds of forest programs that you're describing, or things like the bobolink program, but things where that feels to me like a really fertile area for investment for nonprofits and philanthropy and for government, just finding incentives that pay farmers to delay their harvest or to postpone one of their hay harvests, or to give training and incentives to foresters to say, look, if there's a heron rookery in the area that you're scheduled to cut, wait, just don't, there's good reasons to be patient there and let them finish nesting and roosting, or maybe talk with the landowner about protecting that as its own unique, amazing habitat. Anyway, great questions. I think there's some real promise in those broader habitat protection incentives for landowners. Well, I'm a recovering law professor, so I'm happy to wait, for people.
I have a comment.
Yeah.
I'm not visible. I could be, but I'll spare you. So I was very struck by Vermont's passing this piece of legislation, and Robert, I'm from Connecticut, and Robert's doing a great job for us. I would really like to see us try and push it, although our legislature has promised not to act on anything this year. But when they do resume, I'd love to see it pushed because I think it's a wonderful kind of public announcement, public recognition kind of thing for birds and bird conservation. And so it has a sort of tremendous effect on, getting the legislature to agree that birds are important and want to save them would be a great win-win and would be an underlining of future conservation efforts. So I applaud Vermont. I would love to see more states do it for its sort of halo effect that it would have.
Agreed. Thanks, Benjamin.
David, this is Sarah, and I wanted to just quickly make another comment about what you said, which I think is really important about these great programs that Audubon puts forth with Forestry for the Birds and the Bobbling Project. And this is something that we're working with Mass Audubon and Vermont Audubon with, and also some groups in Maine called Ag Allies, which is a program very similar to the Bobbling Project. But it is maybe a different, it also has the educational, sort of the technical component with it to try to attempt to make some of these practices more sustainable. And I think that's sort of some of the problems with these incentive programs is that we can't continue them unless we have money, right? And so you also spoke to the education, the outreach piece being so important. And so that's part of what the Northeast Bird Habitat Conservation Initiative is really trying to do, is to be able to sort of build these components, taking what Audubon has, what Cornell has, and these great tools and these great programs, integrating them into a large network like the Regional Conservation Partnership Network, bringing in other practitioners as well, all working together to try to make some of these practices more sustainable and then scaling it throughout the Northeast. And so we're trying to do that with, again, with the Bobbling Project and with Ag Allies, where we're adding in the technical piece of actually doing the holistic farm management plans and planning with these farmers. And so hopefully they'll start incorporating some delayed mowing, and they still need to make a profit off their land. So it won't be the entire farm, but it may be a rotational piece or whatever makes sense with their practices. And so that's something that this group is really trying to tackle together, and we appreciate Audubon's part in that for sure.
Well, thanks for that, Sarah. And one of the things that's interesting, that goes both to Sarah's point and in a different way to Benjamin's point, but there's this really interesting opportunity to use birds as this kind of a way to open a door to a broader discussion. On the legislative policy side, the focus on birds, and frankly, also the really strong passion that the Vermont Audubon and birding community of Vermont brought to this really affected legislators. They didn't feel like they had a choice. Nobody wanted to come out and say that they were opposed to chickadees. There's something compelling about birds that brings people together and provides an opportunity for bipartisan or tripartisan, in Vermont's case, coalitions to build, which we really need if we're going to build durable change. And then similarly, when we talk about how to reach landowners or the consultants and foresters, loggers, land management consultants that work with landowners, oftentimes a landowner that might not care about some of the other benefits like reducing nutrient runoff into the lake or the river might care a lot about bird habitat. And if we can design bird habitat, well, as we design bird habitat protections, that is ecologically resilient, it tends to have all these other benefits as well. So if we use birds, we get multiple benefits from this work. So it's just an interesting, this is a breakthrough I didn't have until I came to Audubon and kind of began to look at these issues through that lens. And I'm finding it to be a really powerful aspect of the way that we do our work. And I'm so pleased that there is such a thing as the Northeast Bird Habitat Conservation Initiative, because I think it's timely and necessary. Well, maybe on that note, we're not quite at time, but we're getting close. Unless anyone has any kind of other pressing questions, I will, oh, I see a message from Hannah. Oh God, thanks. Maine has a similar program. So anyway, unless anyone has any pressing issues, I just wanted to thank you all for your time and attention. And once again, thank Katie and Sarah for catalyzing this and helping us to advertise it.
I just want to add to, I just want to do a second shout out to you, David, and to Erik. You guys are thought leaders on this, and we're very fortunate to have you. So thank you for that, and thank you for keeping me in the ambit of your thoughts. So I appreciate it a lot.
Thank you, Rob.
There's a question about slides. Yeah, we'll share. This is being recorded, and we'll also share, because I know Robert and the slides have a lot of great links in them. So we'll get that out to everybody.
All right. Thank you, Katie.
Thank you.
You all. Take care.
Thank you, David. Thank you, Erik. Thank you, Robert. We appreciate it.
Yeah, and thanks again, Katie, too. Thank you so much for getting this together. Thank you.
Thank you.
Bye-bye.
Bye.